What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And as always, I invite you to like, subscribe, visit MMA Payout, visit the YouTube channel, like the submissions, everything in that aspect, as we go along and discuss the business and legal happenings in MMA. And again, we focus this time on the UFC Antitrust Lawsuit. At this point, we already know that this case is up for petition to the Ninth Circuit Court of Appeal to determine whether or not that the UFC will be granted redress, a second shot at the initial ruling by Judge Boulware regarding class certification. However, this episode of the legal submission will take a look at a motion that was filed by the Sparacino Law Firm as it results of allegations from the plaintiff's attorneys that Sparacino, a law firm based out in New York, was attempting to persuade, mislead, provide assistance to potential class members in the UFC Antitrust Lawsuit. Now, this goes back a ways to 2021, and at that point, the class counsel, or the potential class counsel at the time, but basically the attorneys for Kung Lee and the several fighters that filed this initial lawsuit had requested that the court intervene in a situation it had discovered in which the Sparacino Law Firm, as well as another law firm, were attempting to solicit potential class members for this litigation. Now, while the attorneys for Kung Lee do not represent everyone at that particular point, they wanted to make sure that other attorneys were not free riding the work that they were doing. Now, whether or not you believe that that a law firm or attorney could come in and take away clients, whether or not that's an ethical violation or it's fair play, that is subjective, I would say. But the plaintiffs for the Lee party claim that there are mischaracterizations and allegations regarding obtaining fighters that were not privy to the lawsuit to join that law firm instead of joining up with the class. A couple issues arise here. One of ethical notion regarding attorneys. Certainly, it's a competitive field, just like MMA, and attorneys are always looking for business. And in these class action lawsuits, there are always law firms and attorneys looking to find class members, which would be a part of the potential lawsuit. Now, with Judge Boulware granting class certification, the Lee attorneys are designated as the class counsel. They're the main attorneys in this particular lawsuit. Now, what happens next is a letter from the court saying that the fighters that encompass this class that they've defined can now join with the class, the Lee attorneys. They can go ahead and find their own attorneys, which is what Sparacino has been attempting to do, or not be a part of the lawsuit. Just decide, forget it, I don't want to be a part of any of this, and go forward. Sparacino has filed a motion on September 13th requesting that the court validate its previous communications with potential class members. Now, going back, the plaintiff's attorneys had called out Sparacino and another law firm by the name of Scott, claiming that the contact was unethical. they had sent attorney fighters flyers regarding the services needed, and and Lee's attorneys believed that there were mischaracterizations in those solicitations. So what Sparacino has come to request the court is that the communications that they had offered to these potential class members was not misleading and within the ambit of the rules of professional conduct and communication. So attorneys are supposed to abide by rules of professional conduct, and that's across the board for attorneys in the United States. So they want orders saying that the court's like, how you communicated to the potential class members in this lawsuit, that was fine. They also want to be able to solicit potential class members until the deadline, as far as whether or not you choose the class counsel by Lee, choose your own of their attorneys, or opt out. So there's at some point there'll be a deadline, and they want to make sure, Sparacino does, that they are able to solicit appropriately without being dinged for any unethical conduct. They also want to, as very interesting enough, want an investigation into class counsel's attempts to force out other law firms to withdraw and to either be intimidated by them as far as getting out of the litigation. Now, back in 2021, a motion was brought claiming that the communications made by other law firms to potential class members was mischaracterizing the state of the litigation and or unethical. And it's basically Sparacino wanting to clear its name, as well as maybe muddle the name of the attorneys for Lee, because they want to make sure that that investigation is made public. And that probably will not happen, but that's, as you see where I'm going here, this is a fight between plaintiffs' attorneys over business. What they also ask for is sanctions against the Lee attorneys, basically saying, hey, you cannot force out or intimidate other firms out of this particular litigation because you are working within it. So it is more business unrelated to the actual substantive matter of the Zuffa litigation, but it still is an interesting matter, because here we have a lawsuit premised upon the anti-competitive behavior of an organization in which its effects suppress the opportunities of a party. And here you have those representing them allegedly suppressing the rights of a third party to assist the class members that are litigating against the UFC. An interesting side trip in this particular litigation. It's notable that the Sparacino Law Firm hired an ethics professor to provide an opinion as to whether or not class counsel, the Lee attorneys, were appropriate in its intimidation, quote unquote intimidation, of other law firms, and whether Sparacino's law firm was appropriate in communicating with potential class members. This deals more along the lines of what happens when communicating with potential clients in cases, and whether or not there is interference or mischaracterization of facts to influence an individual's decision to hire an attorney. Certainly, from the perspective of the Lee attorneys, they want to make sure they have as many individual clients as possible to be able to litigate this matter. And as class counsel, appointed class counsel, it's assured that most, if not all, class members that have not signed up with an attorney will sign up with them. However, Sparacino indicates in its filing that it is representing at least 15 fighters in this potential case, meaning that they will have at least a say in this lawsuit and the litigation that goes on with the UFC. So it has 15 members, and basically it wants to, of course, get more members. And the crux of this, the big high point here, is that Sparacino is saying that it's not illegal for them to solicit potential class members or members of the class that are not yet represented. What the attorneys for Lee claim is that Sparacino and other law firms are overstepping the bounds in seeking an opportunity to represent fighters in this particular lawsuit. Obviously, the overarching issue is money. Law firms want to sign up as many members as they potentially can to be a part of this lawsuit and potentially win out either a settlement or a verdict. This particular issue is interesting because it does not impact what the Ninth Circuit Court of Appeals will be doing. It's something that Judge Bullard could actually handle himself, depending on whether or not an appeal goes to the Ninth Circuit Court of Appeals. So we will see if Judge Bullard moves much faster here than in his grant of the class certification order. This is Jason Cruz with the Legal Submission. I hope you have a great day. We'll be having more of these coming up in the near future. Have a great day.